Let's take a look at a key case in tort law for occupiers' liability. This case is Rhind versus Astbury Water Park and was heard in 2004. The claimant in this case was Mr. Rhind and the defendant was Astbury Water Park. The claimant dived into a shallow mere that was frequently used by the public to fetch a football, despite warning signs. The claimant suffered injuries as a result of hitting a fiberglass container that was at the bottom of the mere. The fiberglass container was not visible from the side of the mere or those inspecting above the water. It only became apparent when an underwater inspection was completed. It was decided that Astbury Water Park were not liable for the injuries caused to the claimant, Mr. Rhind. This was due to evidence that clearly indicated that the fiberglass container was not known of by the defendants, and nor were they expected to regularly undertake underwater inspections. The requirements of Section 1, subsection 3A of the Occupiers Liability Act 1984 were not satisfied. This is because this section states that an occupier of premises owes a duty of care to trespassers in respect of a risk if they are aware of a danger or has reasonable grounds to believe that it exists. However, Astbury Water Park were not aware of this risk, so were therefore not expected to warn against it. Furthermore, if liability were to have been found here under the Act, there would actually be a defence due to the fact that there was a warning sign by the water, rendering the defendants not liable. Overall, this means that in an exam scenario, if the defendant is not aware of a risk, then they are not expected to guard trespassers against this risk.